Hello everyone, welcome to another lecture for NCA Constitutional Law exam. So today we are going to cover one of the most important topics from whole syllabus, freedom of expression, then second life, liberty, security of the person. In examination you can definitely expect a question, also longer question from one of these topics. So these topics are very important. Firstly, let's read what syllabus says and what syllabus expects us to cover. So for freedom of expression, we have to directly follow section 2B of the charter. And then we have few important landmark cases like Irwin Toy Limited versus Quebec, Saskatchewan Human Rights Commission versus Watt Court. Then for life, liberty, security of the person, we have to go to section 7 of the charter. Then for cases Canada versus PHC Community Service Society, then Carter versus Canada. So these cases address right to life, liberty and security. So starting with topic number 21, freedom of expression. Expression means you are saying something, you have a belief, opinion, thought. So these thoughts include freedom of press, freedom of other communication as well. So this is what is mentioned under section 2B. So you have to go by section 2B for this particular topic. And in this, the very first word says everyone. So everyone here means individuals. R versus Keekstra case, it take out three values of section 2B. So Supreme Court has set three values upon which freedom of expression usually revolve around. So you are using freedom of expression in order to seek or obtain some truth, or it might be that you are participating in some social or political making. Thirdly, it is your own personal individual self-fulfillment for which you are having some thought, some belief, opinion, and you are putting forth it, and for human flourishing. So these are the three values that revolve around section 2B. So now local 558 versus Pepsi Cola Canada Beverages West Limited 2002 case. Firstly, in this Supreme Court said the core values are self-fulfillment, participation in social political making, communal exchange in ideas. Free speech protect human dignity, right to think, reflect freely on one's circumstances. So basically, the court just expanded the meaning, the area, the scope of section 2B in this case. So whenever you're getting a question related to section 2B, you have to use these kind of cases in your introduction. It allows a person to speak not only for the sake of expression, but to advocate change, to persuade others in changing one's life. Freedom of expression generally considered as a negative right. Government cannot interfere with the ability to express yourself. That does not mean government has an obligation to provide a platform for you to express yourself. It's just that government here is not interfering in your expression. That does not mean that government is providing you sources to express your expression. Bear versus Alberta 2007. In some circumstances, there may be a positive right. The court set out a test for when a positive right exists. This test has never been satisfied. Expression under the charter encompasses virtually any subject. The context of the expression is irrelevant in determining if it will be protected. So freedom of expression has been given a very broad interpretation with almost no limitation. Any restriction on expression must be justified under section 1. So here court says that okay, you are allowed to express in any manner. There is no restriction. This is a positive right, but just one thing, that particular expression has to be justified under section 1 if it is being restricted. So you are allowed, the government would not be interfering, but if the government is interfering, that restriction has to be justified under section 1. So this is the only thing. So government here is not using any not word. So there is no negative right. So these are the two cases that just simply gave you an idea about how this section, how this particular freedom of expression works. But for examination, again, I would suggest that you have to mention this case under the scope because it's including all the core values, beautifully defined the meaning and purpose of this section. So when we do section 2b analysis, what are the things that you have to include in your analysis, in your answer? Firstly, you have to define the activity. So any activity that convey or is just attempting to convey a meaning will amount to expression. Actions without words can still amount to expression, like pornography, hate speech. Exception is an activity that takes the form of violence is not expression. Very important. So, terrorism, these actions mainly come from religious belief. So, sometimes in examination, you might get a case scenario in which at one side there will be your right to conscience, your religious freedom, and on the other side, right to expression is there. So you have to see whether that particular religious belief is violent in nature. If it is, then you cannot ask for the protection under that particular section as well as under section 2b. So these actions will not be protected. Second is determine if that infringement of a person's freedom of expression. So court has distinguished this based upon two things. Firstly, content based, any limitation that is directly aiming at the content of what is being said or done. Effect means aimed at another aspect of the activity and you have just incidental effect on your expression. Example, littering. If you drop flyers from an airplane about the government action, you are exercising your freedom of expression. However, you are also littering. Affect your right of expression. So this is effect-based limitation. To claim, it must be shown it clearly restrict an underlying value of freedom of expression. Marketplace of idea, political debate, self-fulfillment and human flourishing. So these are the three basic ideas upon which, these are the three basic underlying values upon which freedom of expression usually stays. So then last you will have to do section 1 analysis. Once it has been defined, determined that there is a limitation, section 1 analysis needs to be done using Oakes test. You will have to see whether government has any particular objective like public safety, security, peace, then in the democracy values or for the fundamental justice, the government is justified in putting these reasonable limits on any of your right. So when we talk about limiting these expressions, how are we limiting? So sometimes there are few prior restraints, like you prevent publication of something just before it occurs. So this is also how you are limiting an expression. You cannot do this. Then border control. Prohibit importing certain material like pornographic book and magazine. This is valid. Then you have penal prohibition. Common restriction coupled with penal sanction like perjury, counseling, suicide. Civil prohibition. Breach of a civil obligation like defamation doesn't result in penal sanction, but it can lead to damages. Forced expression, like requiring health warnings on cigarette packaging, these are all valid ones. Language requirement. Quebec's law requiring public sign ads to be only in French was deemed violation of freedom of expression. You cannot do that. Search of press premises. Searching press premises isn't inherently a breach but must be exercised with caution. Disclosure of journalist sources. No constitutional immunity against compelled disclosure of confidential sources, but common law may develop the reflect charter value. Then time, manner, place. Regulation on how, when, where expression occur, like prohibiting certain ads directed at children, like this we are going to talk about today in another case as well. So these are the ways in which courts have found various issues that were limiting the expression. Few were justified, few were not justified. It all depends whether a particular action passes section 1 Oakes test or not. Then few other subject matter that we are going to discuss under this topic of freedom of expression. Protection of commercial expression. So commercial expression designed to promote sale of goods and services is protected form of expression in Canada or speech in US because it falls under the word within the word expression. It's challenging to distinguish commercial speech from other type of speech. So here we are talking about commercial speech. So commercial speech means you are promoting, you are doing promotion for your sales of goods and services, that is justified. But it has sometimes few advertisement restrictions, like not you cannot involve children of certain age. So these kind of things are justified under section 1, and for this we will be discussing a case today. Language requirement. Prohibitions cannot be imposed on use of English language, and this was established in Ford versus Quebec. Quebec law prohibiting commercial advertising directed at children was upheld by court, that I just told you here. Though it wasn't an absolute ban, the law prohibiting dentists from advertising their services was struck down as a breach of freedom of expression. So these are few examples of how advertising restrictions work under freedom of expression. Then sign. Commercial signs are protected by section 2B as evidence from Ford versus Quebec case. Soliciting prostitution in public places is an offense under criminal code, but is considered protected commercial speech under section 2B, though restrictions are upheld under section 1. Picketing, communicative element, and is therefore considered a form of commercial expression. Picketing is also commercial expression, section 2B. If there are any injunctions, they could be justified under section 1. Hate propaganda. Material promoting hatred against minority group is prohibited, upheld in R versus Keegstra, R versus Zundel case under section 1. Defamation. While freedom of expression is protected by section 2B, false, injurious, wrong statements to demean someone's dignity outside the core value of this section, these are not protected. So defamation cases like Hill versus Church of Scientology, Grant versus Totcop illustrate this balance. Pornography, regardless of its definition, is protected expression under section 2B. However, there are few restrictions justified by public morality, harm to society. Those are upheld under section 1. Access to public property. Section 2B confer right to use public property for expression purposes. Cases like Committee for Commonwealth of Canada versus Canada, Ramstein versus Peterborough established this principle. So if there is some restriction on public property use, that should meet section 1 even if lacking clear standard regarding noise level. Access to court. Freedom of expression including freedom of press, other media communication may conflict with right to fair trial. Publicity surrounding a case can potentially bias a jury. So sometimes there are limitations for people to enter court, to have participation in the hearings. Restriction on reporting. Freedom of press encompass freedom to publish report of court proceeding, but again there are few restrictions in few cases. Then restriction on access. Freedom of press grant the right to press and public to be present in court. Any restriction on access to trial must be reasonable, not absolute, to be justified under section 1 as seen in Re Southam and the Queen. Then Supreme Court upheld a ban on television camera in the legislative chamber, stating that this power was not subject to charter. Contempt of court. Act that offend against the administration of justice, failure to obey court order. Criminal contempt with public significance beyond immediate party is preserved under section 8 of Criminal Code. So section 8 talks about unreasonable search and seizure protection. Public servants are subject to restriction on their partisan political activity to ensure equal diligence in serving governments of all political stripe. Then, orders for employer to provide references to unjustly dismissed employee may breach employer's freedom of expression. Such orders may be justified under section 1 if they have only objective fact. Then election expenditure. Restriction on election expenditure indirectly restrict political speech. So these are what held in different cases. Voting. While the right to vote is granted by section 3 of the charter, it's limited to election of member of Federal House of Commons, Provincial Legislative Assembly. Supreme Court recognized that casting a vote in referendum is a form of expression, but government isn't obligated to consult citizens via referendum. Government isn't obliged to fund or provide specific platform expression to individual or group. Section 2B doesn't grant right to access to any particular statutory platform. So access to government. Access to government document. Canadian government have enacted freedom of information legislation to provide public access to government document with some exemptions. Supreme Court has held access to information is a derivative right that may arise where it's necessary precondition to meaningful expression on the functioning of government. So now we'll be talking about three important landmark cases. First one is Montreal versus Quebec Incorporation 2005. Court expanded on the test for freedom of expression. So a business was operating a strict club. They had set up speaker that had amplified commentary of the show, and that commentary out of that strip club was coming out on the streets. So anyone who was passing by that street could hear those announcements through speaker. Business was found guilty of the city's bylaw. So the local city bylaw concerning noise, which prohibited noise that could be heard outside. Superior Court squashed the conviction on the basis that by law infringed their right of expression, and this infringement could not be justified under Section 1. And Court of Appeal also upheld this decision. So city again appealed to Supreme Court. Supreme Court held that there was infringement on the claimant's freedom of expression, however, said it was justified because the objective of combating noise pollution was a pressing and substantive objective. The laws met the factors of the proportionality test. So here limit that was on the noise produced by the equipment was rationally connected to the objective. The measure impaired freedom of expression in a reasonably minimal way. There was no other practical way to limit law. They also said the location could also determine whether or not there is an infringement. So all these things affect. Then another case, Saskatchewan versus Watcott. Four complaints were filed with Saskatchewan Human Rights Commission concerning flyers distributed by Watcott. Complaints were that flyers were promoting hate against homosexual, keep homosexuality out of Saskatchewan, out of public school. So this was what was written on the flyer. So tribunal held that flyers contravened section 14 of Saskatchewan Human Rights Code because they exposed persons to hatred and ridicule on the basis of their sexual choice orientation. Section 14(1)(b) states that no person shall publish or display represent that exposes or intends to expose to hatred, ridicule, belittle, otherwise offend the dignity of any person or any class of person. So Watcott claimed they did not violate Human Rights Code because statements were truthful. And this section, they say, is unconstitutional. It is violating their freedom of expression. So tribunal concluded that section 14 was a reasonable restriction. So this was required so that people could not be exposed to any kind of hatred. So Watcott appealed to the Supreme Court. Supreme Court in their decision discussed the meaning of hatred, identifying three prescriptions of the definition that what could be included under hatred, because when we do this thing, the expression, the thing that is in question, we have to go to the deep details of the definition of that thing, whichsoever is in our issue. So the term hatred has to be objectively determined because this is the main term, hatred, that is mentioned in that particular 14(1)(b) section, and this is the main issue of concern. So would a reasonable person aware of the context and circumstances surrounding the expression view it as exposing the particular protected group to hatred? Hatred has to be an expression that is more than offensive. It has to incite manifestation of detestation. So hatred does not mean that you can just mention this word in the legislation if the effect of such flyer is actually hatred. It is actually manifesting of detestation to someone. It is actually offensive to someone. Then only you can say that you are exposing someone to hatred. The tribunal must focus their analysis on the expression at issue. It is irrelevant if expression intend to cause harmful conduct. What is important? It is likely to expose, just what I told you, likely to expose the targeted group to harm from others. That you are doing harm to someone, that is important. You have to check that. So Supreme Court focused on Section 1 analysis. Court has no difficulty in determining there was pressing substantial purpose for which this human right code was made. This particular section was made. So under the proportionality test, the courts held there was a rational connection between protecting group from hatred, but the words that were used in the code in this particular section are overbroad. So ridicule, belittle, otherwise affront the dignity of did not rise to the level of extreme feeling constituting hatred. This part was not rationally connected to legislative purpose. The purpose for which the legislation was made, this particular part that was in question was not rationally connected, was not required. So court said once these words are taken out from the law, from the provision, then it would be valid. So this is what the court told as remedy. Court said minimal impairment test was satisfied. So this is what we just read about. So court read down section 14(1)(b) and upheld its constitutionality. So when we talked about earlier remedies, we saw at one time there was a concept of reading down. So reading down means whatever is in interest of the particular constitutional right, the court will read that particular provision to that effect. So here also court said benefit of suppressing hate speech, its harmful effect outweigh the detrimental effect of restricting expression. So the purpose is more important for which this code has been made. That is why here that purpose is over this restriction of expression purpose. So the flyer thing was wrong and court read down section 14(1)(b) and said that this is constitutional, this is not against freedom of expression. So next is Irving Toy Limited versus Quebec Attorney General. Respondents had broadcast advertisement to children. It was argued that they had violated the Consumer Protector Act. This legislation government had hoped to protect children from advertisement. Supreme Court found that Consumer Protector Act did not have the purpose to exclusively regulate TV advertising. Purpose of the act to protect the consumer was valid. The court did not find that act infringed on the right to commercial speech. So if you are not including children in your advertisement, it does not mean that particular act is infringing on your right to commercial speech. Court of Appeal held that Act did not serve an important enough legislative purpose to justify the Act interference with commercial speech. So Supreme Court first considered whether to conduct was within the scope of protection. They found that it was as advertising attempts to convey meaning and therefore meets the first factor. Then they looked to whether government had tried to restrict freedom of expression with relevant sections that are targeting of children not involving in these advertisements. So they found that the purpose of those provisions was to protect speech. The respondent argued that under the charter the act was void of vagueness and provisions were confusing and contradictory. Court did not agree to this. Court said act is providing an intelligible standard. The court had to use Oakes test to determine whether this government's interference in this commercial right is valid or not. So court found that there was substantial pressing purpose to this legislation. The purpose was to protect children from being manipulated by involving as actors in advertisement. The court found that ban was rationally connected. It was minimal impairment. There were more benefits to limit the right than harm if they did. The court found the ban did not violate the charter. However, it is important to know that commercial speech can be protected by charter. So that is another issue. Here the issue was ban on children being involved in advertisement is against charter, but court said no, this is valid use of section 1 by the government. So to conclude topic number 21 related to freedom of expression, whenever you are getting a question on this, you will have to see, firstly, does the charter apply? Is the infringing party the government or a government agent? Then the activity that is in question, whether that activity falls under the definition of expression, you have to define that particular activity. that that particular activity is trying to convey us the meaning of expression as per section 2b. So court has interpreted section 2b broadly, and any interference is done by section 1 justification with except of violence. So you have to go for section 1 justification as well. Then, does the law or action have the purpose or effect of limiting a person? Is that law, legislation, government action directly limiting person's freedom of expression? So for that you have to see two things, whether that limiting is content based or effect based. Content based means when directly they have a law or action that has purpose of restricting a particular expression. Effect means as a result of that your expression is being impacted, like effect at some other aspect of an activity that has an impact on your expression. Then lastly we will go for Oakes test analysis, whether this infringement on freedom of expression, this limit, has reasonable limit link as per section 1. So we will do section 1 analysis. So we are done with our 21st topic. Now moving to next topic, 22nd, life, liberty, security of the person. Section 7 of Canadian Charter of Right talks about this. This section basically guarantees. It gives guarantee that okay, till the time Constitution is here, you are on Canadian land, your life, liberty, security cannot be deprived, your life, liberty, security cannot be infringed, cannot be interfered with. So it is 100% protected. So section 7 guarantees everyone right to life, liberty, security, and right not to be deprived thereof except in accordance with principle of fundamental justice. So this right can only be deprived if principles of fundamental justice, the state feels that in order to have peace, someone's life, liberty, security has to be interfered with. So this is just one exception. Fundamental justice. What all things comes under fundamental justice, that we will talk about later. So here you have to understand that section 7 is important section that you have to mention in examination. If you get a question related to life, liberty, security, there is just one exception, fundamental justice. If the government is upholding the principle of fundamental justice, then only they can deprive any person of this right. Otherwise, 100% you are guaranteeing everyone, every person right to life, liberty and security. This section's interpretation depends upon case to case. So because this is a completely evolving concept, what is life, what is liberty, what is security, even what is fundamental justice, these things expands with time as more and more cases issues come before court. So then they decide that okay, whether we can include this thing under right to life or not. So this is an expansive, not restrictive section. Everyone, when we see this word written here, everyone, this straightforward means that every person who is physically present in Canada, even if they are in the country illegally, it does not extend to fetuses or corporation. So these two things are excluded. Unborn child, fetus and corporation company. Other than that, everyone. So it doesn't say citizen, it doesn't say who hold permanent residency. So this section is saying that everyone, no matter you are an immigrant in Canada, still you have right to life. Right to life, liberty, security of the person. Life means the normal life. Due to Canada's abolition of death penalty, instances where a person's life is being deprived are rare, usually involve government action that endanger life. It's important to know that life does not encompass basic right like normal standard of living or right to basic income. It means your own life, your own living. Nobody can take your life from you. Alive. So these things encompass under the term life. Then liberty means freedom. It encompasses freedom from physical restraint. Nobody can physically restrain you, like kidnap you or any way they can physically restrain you. Any law imposing penalty of imprisonment constitute deprivation of liberty. For imprisonment to be lawful, it must adhere to principle of fundamental justice. So here they are saying that, okay, we send people to jail, but that is as per law. That is as per fundamental justice principle that is required by the law. If you are sending someone to jail, that does not mean that you cannot physically restrain that person because section 7 says so. No, that is one thing that comes under this exception of principle of fundamental justice. So this is what I was trying to explain you in the beginning of this topic, that nobody, no government can restrain you. No government can endanger your life, liberty, or security except if that particular action is as per law, is as per fundamental justice. Deprivation of life does not extend to privilege like driver license, nor does it protect lifestyle choice. Government action amounting to deprivation of liberty include mandatory fingerprinting, compelling oral testimony, prohibiting loitering. So these are the things that sometimes on part of government include your deprivation of liberty, like your choice, when someone is interfering into your choice. While liberty protects fundamental personal choice, it does not extend to lifestyle choice. So your lifestyle choice does not come under this. So scope of liberty, as I told you earlier, even the scope of this whole section is broadly interpreted. Certain fundamental choices are protected like abortion as they relate to autonomy rather than lifestyle. So lifestyle things, for example, you are drunk, you are smoking in public places which is prohibited. So you cannot say that this is my lifestyle. You cannot stop me. No, definitely government can stop you from doing that. Security of the person. It means your personal freedom, autonomy, integrity. Your security. It includes psychological, mental security as well. Section 7 protect individual from serious psychological stress that is imposed by certain government, provided that particular imposition exceed ordinary normal stress or anxiety. Government action safeguarded under security of person include delay in assessing healthcare. So these are the instances, examples that include government action, safeguarding under security of person, assessing abortion, facing deportation to a situation involving death or torture. So these are the things. Deprivation. So deprivation means a situation where someone is taking an individual's right or freedom. Your right are being deprived, taken away from you. You are losing something. So that means deprivation. So deprivation required that the government be responsible for causing the limitation or loss of rights. If anywhere your rights are being deprived of, then government is responsible for that consequences. So there are few important cases like Operation Dismantle versus Queen. The court emphasized that there must be clear connection between government action and deprivation. Uncertain hypothetical harm does not constitute deprivation. However, there does not need to be an unbroken chain between government action and deprivation. So if government is doing something where there is a situation that government is putting some limitation on individual rights or freedom or is taking away, so that should be certain, specific, clear cut. You cannot just think on your own that okay, government is doing this. It should be clearly seen from the actions of government, only then it can come under the definition of deprivation. Next, we have case of Canada Prime Minister versus Khader. Despite not being directly responsible for Khader's detention, Canadian government action contributed to his ongoing deprivation of right. Because Canadian government shared information about Khader with US despite knowing he was being tortured. So this was straightforward deprivation of his rights. Then what is principle of fundamental justice? So fundamental justice means those guiding principles that determine, that decide whether particular limitation on individual right or freedom is according to charter or not. So here fundamental justice principle requires that There must be procedural fairness. Individuals are treated fairly in legal proceeding during trial. There must be substantive fairness. So the fairness that you are doing should be seen. This could involve consideration like whether it is just to punish someone even if they are guilty of a crime. Then jurisprudence. Interpretation application of the principle of fundamental justice, especially when we relate them to section 7, have been challenging according to legal precedent. So there have been many cases where these actions which government says are as per fundamental justice are being questioned before the court of law. So jurisprudence is that the interpretation is still ongoing, challenging. There is no clear-cut definition related to what do we call fundamental justice. Basically, in simple terms, any action of government which includes procedural fairness as well as substantive fairness. In BC Motor Vehicle Reference case, Justice Lammer provided reasoning why fundamental justice extend beyond mere procedure. Like I told you, it includes substantive justice, substantive fairness also. So despite the residuary theory of Section 7, there are challenges as the provision of Section 8 to 14 are not drafted as residual clauses and are not confined to life, liberty, security. Defining fundamental justice has proven challenging, with subsequent cases demonstrating disagreement over what constitutes. So the judge says in this case that there had been controversy. There had been no clear-cut solution to what may constitute fundamental justice. So there had been continuous disagreements over this concept of fundamental justice. So when we see the cases in which fundamental justice was being questioned, one important case that we have to discuss is the Malmo-Levine case. Court outlined three requirements. So court says if something has to come under principle of fundamental justice, it has to follow three requirements. So this case is very important for this whole topic. So these requirements include rule being a legal principle. Whatever government is making a rule, that has to be something legal in nature, a law, a legislation. Having significant societal consensus. It should be required for the society. Then being capable of identified with sufficient precision. Whatever rule, whatever legislation the government is making for a particular limitation of right, that has to be clear cut, not uncertain, nothing confusing, nothing indirectly, has to be identified with sufficient precision. However, subsequent cases like Canadian Foundation for Children case have shown that not all principles meet these requirements. The residuary theory of Section 7 imposed limit on scope of fundamental justice, introducing additional uncertainty. So although under Section 7 under the residuary theory we have left with the judges to interpret the provision of Section 8 to 14 as per their own judicial minds, judicial activism, and to see whether the particular facts fall under principle of fundamental justice or not. But here, still, in many cases, fundamental justice concept has still being challenged, still being disagreed on. So next is the topic of absolute strict liability, categories of offenses. So whenever we talk about any crimes, any offenses, there are generally two kind of offenses based on intention to commit crime, based on intent required to establish guilt. So these are absolute liability, strict liability offenses. Absolute liability offenses are those which do not require the proof of mens rea. We know that crime include two things, actus reus and mens rea. Although these topics will be discussed detail when you will be writing the criminal law exam, but here you should understand that crime constitute two things. Actus reus means action. Mens rea means the guilty mind. So for the absolute liability offense, you do not need mens rea. Simply committing the prohibited act is enough for conviction. So R versus City of Salt Street Marriage, Supreme Court of Canada classified offences into three categories, one being absolute liability. Then motor vehicle reference case, Supreme Court of Canada declared absolute liability offences violating the principle of fundamental justice. So Supreme Court said these offences are directly violating the principle of fundamental justice. However, it's possible for Parliament to create such offence as long as no penalty of imprisonment is involved. So, this case came before the court in which they said that absolute liability offences which straightforward establish the guilt of a person are against section 7. They are depriving a person his liberty because you are directly declaring a person as guilty one. So in this case, Supreme Court of Canada declared that absolute liability offences are violating the principle of fundamental justice. However, absolute liability offences can be created as long as you are not sending the person into jail. So as long as no penalty of imprisonment is involved, these absolute liability offences are good to go. Then strict liability offences. Unlike absolute liability offences, these offences do not require proof of intent but allow for a defense. So here you have defense of due diligence that you can use before the court of law. So Supreme Court of Canada determined that regulatory offences like these don't necessarily imply moral blameworthiness and can be devoid of mens rea, the intention satisfying fundamental justice with a defense of reasonable care. So these offences, strict liability offences, are not against fundamental justice. So this was held in R versus wholesale trade because here the penalty included fine or imprisonment. So here or is mentioned, and also mens rea was not required for false advertising. So you have to see in examination if you're getting a question and you have to decide upon fundamental justice concept. Firstly, look whether the offense is absolute liability offense or strict liability offense. Although this is again not a criminal law examination, so the case scenario would directly give you hint about what kind of offense is there in the issue, but still you can, in order to expand your analysis, mention about these two categories, then directly go to the case for your analysis, whichever category is in question. So in absolute liability, we have seen that these are against fundamental justice concept and against section 7. Strict liability has nothing to do such, so they are good. Then we have involuntary act, automatism. So these are those acts that you do under some kind of influence. So voluntariness is a fundamental aspect protected by section 7. For offences which carry imprisonment penalty, law respecting automatism hold constitutional status. So in order to protect fundamental justice concept, we have few defenses that we can use. So as per fundamental justice, if a person is doing something involuntarily, someone is forcing that person, then that person can use this as a defense. If someone will try to abolish or restrict the defense, that would be unconstitutional unless it is justified by section 7. So then we have duress. Duress is also similar kind of offense. So if someone again is doing some act under pressure, fear of threat, then it's a breach of fundamental justice if you're convicting that person, because that action will also be considered as involuntarily. Then intoxication. So extreme intoxication, that level that you cannot understand the consequences of your action, is a defense to criminal charges. So all these defenses that I'm talking about related to strict liability offenses are as per fundamental justice. So Section 7, if it is in question, someone's life, liberty, security is in question, and you have to decide, you have to use your legal analysis, then check whether it comes under the exception of fundamental justice or not. Then accordingly you are going to defend your client. So next concept that comes under section 7 is related to different law. So we simply saw what the definition is saying. So we read that section 7 is protecting everyone, every individual, his life, liberty, property, as long as that person is physically present on Canadian land, and there is just one exception, fundamental justice. But fundamental justice has to be read in both ways. Government can also use it to deprive someone of liability and security, and fundamental justice can be used by a person as well under a defense. So it goes both ways. So now section 7 talks about few kind of laws. So over broad laws. So laws broader than necessary are unconstitutional. Overbreadth means those laws that are vague. So if government is enacting some law and that law is related to section 7 and it is vague, unclear, overbroad, then that is unconstitutional. Then laws must pursue a legitimate state interest. There has to be something related to fundamental justice. If there is a disproportionate law that breaches fundamental justice, that would be unconstitutional. So arbitrary laws lack a real connection to their purpose and breach fundamental justice. So all these are not acceptable laws. Then vague law, as I told you here, unclear law, are also violating fundamental justice principle by not providing fair notice, clear standard. So if a government is enacting some law related to section 7, the law must meet a standard of precision to avoid being unconstitutionally vague. Vagueness applied to other charter rights, including right to bail, protection against unreasonable search and seizure. So it goes just beyond section 7. It includes all the procedural things as well. That is why everything will come into question, everything will be at risk, and all these things ultimately are breaching fundamental justice, so we cannot do that. Accused must be tried and punished under the law in force at the time of offense. So this is right way of going for section 7. So if someone's life liberty is in question, but that person is being tried and punished as per the law, then that is justified, then section 7 is not violated here. Every person has right to silence. This is a fundamental principle. This prevents someone to self-incriminate, to say something against himself or herself. Then fair trial. Principle of fundamental justice require fair trial, reasonable hearing. Then in every matter, no matter it is a criminal case, civil case, administrative case, right to fair trial is right of every person. In Bedford versus Canada, three sex workers challenged the constitutionality of certain sections of Canadian Criminal Code, arguing that these sections violate their rights under Section 7. So this is one of the most important case directly questions Section 7. So three sex workers challenged the constitutionality of certain sections and said that particular sections are violating their right to life, liberty and security, which is protected, guaranteed by Section 7. So what was the argument? Sex workers contended that their liberty was infringed because they faced imprisonment if arrested and convicted under these sections. They argued that their security of person was compromised because they were unable to take proper precaution to protect themselves by working. So what were the challenges? Criminal code provision in question made it illegal to operate a brothel. So for these sex workers, it was illegal as per the criminal code provision to operate a brothel. Then forcing sex workers to work in more dangerous environment. Then they were also prohibited from having bodyguards or screening clients. Government responsibility was to establish a violation of Section 7. Sex worker needed to demonstrate that the government was responsible. So court decided that criminalization of certain aspect of sex work indeed made the profession more hazardous. So there is no need to criminalize because directly here sex workers' work is to run brothel. So here a clear causal connection between law and deprivation of right can be seen. So their right to life, their life to earning, all those things, their livelihood comes under Section 7. So in this case, court took out the concept of three kind of laws that we discussed earlier, but we discussed there in brief. Here we are going to talk about these three things in detail. So court noted that the law that was in question was arbitrary, illegal, lack rational connection to its objective. The objective with which those laws were made had no connection with the purpose that they wanted to achieve. So they did not effectively achieve their intended goal. Instead, dangers for sex workers were increased because now they had to do those things in order to have their livelihood closely in closed premises by the risk of having imprisonment in mind. Then overbroad, the law is considered overbroad as it denies the right of individual not intended to be affected by its purpose. So this is overbroad, restricting the right of sex worker without effectively targeting the intended objective, intended goal is something unnecessary. Then thirdly, it is also grossly disproportionate. Excessive penalty has been imposed. So this is now how you are going to achieve the intended objective. The court found that the limitation imposed by criminal code and sex worker were grossly disproportionate to objective of law. Impact on right of individual is definitely affected here. So now in examination, if you are getting a question related to some legislation enacted by the government that you think is infringing certain person right to life, liberty and security, you have to pass these three tests. You have to check these three things: whether the law is arbitrary, whether the law is overbroad, whether the law. So then we have another important case of Canada Attorney General versus PHC Community Service Society 2011. So in this, what happened? In order to control the drug users from getting involved in some kind of risky methods, injection drug use peaked, leading the government to assist. So government decided to help these drug users at all treatment levels, including supervised consumption facility where they can do all these things under particular supervision of government. So facility was granted exemptions including the supervised consumption facility. So facility was granted exemptions from federal drug laws but faced denial when applying for new exemption. So they were trying to renew these exemptions in 2008, but then the government they denied for this exemption. So section of Controlled Drug and Substance Act giving the Minister of Health discretion to grant exemption. So it was the discretion of Minister of Health whether that particular minister wants to give this exemption or not. So this is as per one of the section of this act. So the issue was that this section is violating section 7 of the charter because this particular policy was made in order to protect the life of these drug users. So section 7 was in question. Appeal and cross appeal was dismissed. Minister of Health was ordered to grant exemption further under section 56 of CDSA. So what was the reason? So reason include prohibiting drug possession, engage users' liberty, interest and right to life and security. So as per this particular policy, everything has been done under particular supervision because you cannot take away these kind of things from drug user at one time. that will definitely affect their life and liberty, that will definitely gonna affect their main living thing. So that is why with this intention, with this objective, this policy was created. So section 56 grant minister broad discretion to grant exemption. So court said rather than using the section that is not granting exemption, minister has to grant exemption under section 56. Failure to grant will definitely affect section 7 and it is going to affect the principle of fundamental justice. So minister has to work as per charter, must conform to charter. Denial of exemption was grossly disproportionate, serious harm, given the facility's positive impact, because here this facility which is assisting drug users at all treatment levels is doing something for the betterment of society, doing something for public safety and health. So this is a positive impact under fundamental justice. So you cannot take away this thing. This would be very disproportionate. So result was section 1 was not argued because we already saw that fundamental justice principles of public safety harm already been included, for which purpose that law was made. Mandamus order issued to minister to stop going further with not exempting and to grant an exemption under section 56. So then another important case, Carter versus Canada. Supreme Court of Canada examined constitutionality, validity of section 241 of Criminal Code, which prohibit assisted suicide. So when someone is suffering from very heinous problem, very high life risking disease that the person don't want to live further, so sometimes for this we use term euthanasia as well. So there is assisting dying, assisting suicide kind of thing that is under section 241 of Criminal Code. So in this case, this particular assisted dying with the help of doctors, that doctors can help a particular person in dying, or they can just turn off the ventilator on patient's demand or patient's family's demand. So, but this process of assisted suicide dying was prohibited by section 241. So plaintiff's argument was, there were three plaintiffs, they argued that this section 241 is infringing upon right to life, liberty, security, that a person has full right to take decision. But court said, Supreme Court agreed with plaintiff, said that 241 no doubt is violating section 7, but we have to look into the objective. It's not every time that there will be assisted suicides that would be legitimate. Sometimes if a human being is assisting another human being in dying in suicide, then we all know that humans do make errors. You cannot take 100% guarantee that even if a person is a doctor, they won't go for any kind of forced, coerced suicides. So, preventing vulnerable individuals who are not able to make their decisions properly, who are risky, like old age people, from being coerced, forced into suicide was deemed legitimate. But blanket ban on assisted suicide was considered overly broad. So, complete ban is not necessary, but objective is as per fundamental justice. Main plaintiff in the case was not seeking an immediate right to die, but rather an autonomy to decide when to end her life if her suffering became intolerable. So court recognized that okay, definitely your wish is as per your right to life. Government argued that the objective with which this law was made was to preserve life. So court rejected this government's broad interpretation, instead focused that aim is to prevent vulnerable individuals from being induced, forced to commit suicide whenever they are at their weak period. Like you're suffering from some disease, you at some point you will feel that okay, this is intolerable, unbearable, but then later after 2 3 days again you are recovering from it. So when you are feeling that it's unbearable, if some person forces you to go for assisted suicide, then definitely you might think that okay, this is unbearable, this is not going to recover, I can go for dying. But then these kind of things are what are protected by this section 241. So law needs to be narrowed down. So court decided that we have to narrow down the scope of law, allowing assisted suicide for competent adults who are freely consent to end their life due to grievous medical condition causing intolerable suffering. So only these kind of people who have full capacity, who are mentally fine, only they can give consent to end life. If a person is of old age suffering from some kind of old disease like dementia, or a child who cannot make their decision, so those people cannot give consent to end their life under this process. So last is property. Does property rights come under charter? Sometimes people say that this is also our liberty, our life decision related to property, but exclusion of property from charter was a deliberate decision. Omission ensured that other protected rights do not inadvertently include economic liberty and security. So here the liberty we are talking is personal, physical, security, psychological. It does not include economic, money related liberty. So economic rights, this question was raised whether Section 7 protect this economic right in Siemens versus Manitoba Attorney General. Court established that economic rights, including the right to engage in specific professional activity, not protected under Section 7. Property right, including right to practice a particular profession, has been explicitly excluded from Charter and Section 7. Then there was College of Physician and Surgeons case. The case reaffirmed that Section 7 again said that Section 7 does not include right to practice in a specific profession. Revocation of professional license was deemed not to constitute infringement on individual's security of the person under Section 7. So that you will have to go for departmental things. So now to conclude, whenever you are getting a question Section 7, what are the steps that you have to follow in examination in your analysis? So 5-step test. Step 1. Which of life, liberty, security has been infringed? Because there could be more than one right that is infringed, your life as well, your security as well, or there could be two rights at one place, like right to equality as well as this Section 7. Then is this infringement deprivation is coming from some government legislation, government action policy? Is there a sufficient connection between this law and your deprivation of right? Is this deprivation justified and is within the principles of fundamental justice? So here we will see the government's purpose. Then we must see for this question, step 4, that the law should not be arbitrary, should not be overbroad, should not be grossly disproportionate. So then we will see, even after going to this test, we will lastly see whether Section 1 saves government action or not. So this is how you are going to write your answer in examination whenever you're getting a question on Section 7. So that was all for today. Thank you and good luck.